And what I would be concerned with if I were on the other side of these election contests that are going on around the country is that, if you look at the level of evidence that has been provided by these affidavits, hundreds of affidavits that corroborate events that have happened on the ground, um, in a summary judgment phase of these cases, you have to take the evidence of the plaintiff as being true. The court has to take the evidence of the plaintiff as being true and see whether or not the other side can make a case against it. So the massive amounts of affidavits that we see in these cases show that there was, in fact, fraud that took place. And the other side really needs to answer these questions so that
Well,
we can have.
let me ask you that because I'm not a lawyer, but the phrase "innocent until proven guilty," what you're saying is the reverse in the sense of you're saying that the charges are assumed to be true of fraud. Is this a different standard under election law?
It's not a different standard, but one of the initial things that happens in these type of cases, especially in a federal case, first you have to overcome what's known as a 12b6 motion, which is, did the plaintiff state a case for which relief can be granted? Clearly, in this case, they've stated a case for which relief can be granted. So then the next phase of a trial would be the plaintiffs making some sort of motion for a summary judgment, saying we have irrefutable evidence that fraud took place. And the other side would have to put up some evidence. And in a summary judgment phase, you take the evidence of the plaintiff as being true and see whether or not there's enough evidence to go to trial. And so at the end of the day, what I would say is that these are legitimate accusations that are going to be tried in court, and we need to let this legal process play out so that we come to a valid conclusion to this election that everybody believes to be legitimate.